Always permit my lord. This was due to appear on 18th by matter.
With the leave of Honorable Justice Chatterjee Das, may I permit to mention one review application of your Lordship and Honorable Justice Bhattacharya. Some urgencies there, we are facing a threat of contempt.
Next week,
It's in the Manrega matter. Millards wanted me to come back this week for.
Probably next Wednesday or so.
Millards, this Monday the matter is supposed to come up in terms of Millards' last order.
No,
on
it is before
18th.
the other bench. No, this bench.
No, this bench, Millards. This bench.
Then you list it on.
Monday, Millards fairly higher on board so that the matter can reach Millards. I'm grateful. I'm deeply grateful.
My lord, may I mention one matter? My lord was pleased to decide the appeal on 2nd August 2025. There is some typographical error, my lord. My lord, in other matter, directed the authority to grant the refund of interest within 6 weeks.
To be mentioned.
Grateful, my lord.
Let the file come.
Lordship, may I be permitted to mention one matter? First of all, I am tendering my apology because the matter was called on 7th. But I was engaged in the different court. That is why I could not reach before your Lordship. I am tendering my apology.
No, tomorrow it's appearing.
Tomorrow, my lord, it may be in a reasonable place, but as the matter could be.
Next week. Higher on.
Tomorrow?
Next week.
Next week, any date, my lord?
To file an appeal on the basis of a server copy, Lordship.
Oh, it's a tax matter.
It's a tax matter, Lordship.
When date of the order?
4th of August, Lordship.
Good day, sir.
Yes, Mr. Kohli.
Good morning. So you had said send me to DRT, that will get justice there, but they rejected me.
We didn't send you to DRT. We passed an order.
Oh, okay, that's what I mean. So anyway, they've given the order against me, and
DRAT?
No, sir. We have filed a revision in the revision court of Mr. Hiranbhai Bhattacharya, but he has released the matter saying he was part of the original hearing here. So he's asked me to assign the case.
If the file comes, the order has already been signed?
Yeah.
I think yesterday I have already assigned it.
You already assigned it?
Yesterday I think I have signed.
Sir, please do it, sir. Sir, what they've done, they've given me they are taking over my property on 2nd September.
If I have not done it yesterday, it will be done today.
Okay, sir. Okay, sir. So I'll get the check on the website tomorrow. Will be there.
Or you can do one thing. Can you go to the OSD now? Samrat Gupta.
Where is he?
He is there. Just they'll guide you.
Okay.
He will inform you. If I already assigned, it will be.
Okay. Thank you very much, sir. Sir, look at this. Nobody can be NPA during the moratorium period, sir. I've been made NPA by State Bank of India during the moratorium period.
But you are unsuccessful before the tribunal. What to do?
Sir, I have given the thing. He's ignored it. Can you imagine? So he's ignored it. He's not mentioned the order. And in the order, he said things which I've never said. He said, I've given writing. I've never given any letter.
All right.
Please, sir. Thanks very much.
My lord, kindly give me leave to file a review, my lord, on the basis of the server copy. I have already applied for
review of which order? That is that
my lord's order, my lord.
Jurisdiction. Whether you have to go to Delhi or to Orissa or
Orissa. I went to Orissa. I went to Delhi. They are saying you cannot file registry. You will not take a case against DVC.
You file it. Ask your advocate to file it.
I have went there. I talked to so many advocates.
No. You let them reject it.
They told me to go to Supreme Court. From Supreme, I went to Supreme Court also.
Then Supreme Court you can't go.
But they said
you have to go to Delhi,
and then only it can be done. Because DVC is here, your complaint is here.
Sir, we have already given reasons. For your satisfaction, we can.
Sir, my prayer is.
We can list the review, but it is a very bad court for.
I know, my lord, that it will not be done, but my submissions can be recorded, my lord. Only that is the purpose, my lord.
You take that.
Please record my submissions, my lord.
Lordship, may I kindly to mention an appeal from SESTAT. It's an appeal of 2009. This matter was mentioned. Lordship has sought to hear the matter.
Lordship, my lordship, namaskaram, Andi. I being advocate in person, but in these times out of West Bengal, local town police and Kharagpur police not cooperated, threatened me. Whatever now, I am cardiac patient.
This is if it is a Group 9 matter, it is before the single bench.
Sir, Mr. May talk to about your Hindi.
No, you explain which is Group 9.
Hindi.
No, you find out.
Allow me to say.
No, which group is the matter?
सर
कौन सी ग्रुप का कौन सी ग्रुप
सर आपने रीड 3 बार किया सर, सब डिसमिस हो गया। खड़गपुर कोर्ट, मिदनापुर कोर्ट सब हमको डिसमिस कर दे रहा है। लोकल टाउन पुलिस
Then
कोऑपरेट नहीं
you
कर रहा
file
है।
a revision or a criminal revision, Midnapur court order. You are an advocate. You are appearing in person. You know the law better.
सर आपको हम लेट 3 बार चिट्ठी किया, कोई जवाब नहीं सर। बार काउंसिल में चिट्ठी किया,
Where
मैं
how
क्या
to
करूं
get
सर?
in this?
सर वैसे नहीं होता है, आपको प्रॉपर प्रोसीजर फॉलो करना है ना।
सर क्रिमिनल किया सर 3689 2 साल से किया, कोई एफआईआर नहीं हो रहा है।
No, has he filed the matter?
सर आपको देखिए पूरा कंप्लेन सब लेटर फाइल किया सर, CRR 3689 2 साल से कोई एफआईआर नहीं हो रहा। हम घर का बाहर है सर। सर मैं क्या करूं सर? मैं एडवोकेट होकर मार खा रहा हूं सर, कोई मदद नहीं कर रहा हमको।
But unless you have filed
सर
the
15
matter,
अगस्त भी आ रहा, हम तो आजादी नहीं, हम तो डर के छुप के भाग रहा है। और यहाँ 21 लोग घूम के हमको मार रहा है सर।
have you filed a matter in the High
हाँ
Court?
सर सब किए तो सब
What
क्या
is
हुआ
the
सर
case
इसमें?
number? Case number है.
CRR 3689
All right. 3689, where it has to become
2023 कोड नंबर 22।
हाँ, it is running in the list.
अरे नहीं सर, पता नहीं सर, मैं यहाँ आने मांग रहा, कोर्ट को रिलीज भी नहीं दे रहा सर, मैं क्या करूं?
You take, has he
सर हम
written a
कार्डियक
letter?
पेशेंट है सर, हमारा ब्लॉक हो जाएगा तो कौन
But
आएगा, मार खा जाएगा। हम कोर्ट के बाहर गिड़गिड़ा रहे, कुछ नहीं हो रहा है।
Wait.
but I find there is a order of District Court of Paschim Midnapur in the Additional Court of District and Session Judge, Criminal Division number 249 of 2023. Judgment was delivered on 4th August 2023. Perhaps not challenging this, assailing this order, Milord Criminal Division has been filed. I do not know, but there is a order of Milord Additional District Judge and Session Judge, Fast Track Court, Sodor Paschim Midnapur.
But he says that he has filed a revision. Criminal
Revision Milord. What is the petition? Revision petition.
ये कंटेम्प्ट किया था, कैंसिल कर दिया।
But there is also a
ये तो रीट था।
one read petition is there, Milord, WPA number 10770 of 2021. Justice Honorable Justice Mantha. Milord, there is a direction of this Honorable Court also. Milord, here is the order is that none appears for the petitioner despite
dismissed.
No.
You didn't appear.
नहीं अपील किया सर,
Jabasish Datta.
हाँ इन पर्सन में किया
That's
सर।
the state of West Bengal, CRR 3689.
हाँ
It came before the Honorable Justice Uday Kumar on 8th of August, and you did not appear, despite appearing in the list under the heading to be mentioned at your instance. Let the matter go out of the list. You go and mention before the Honorable Judge.
सर पता ही नहीं है तो रूम बंद रहता है।
Nothing. Please call the list.
अच्छा पुलिस जो थ्रेट करे सर, पुरुषोत्तम पांडे फॉल्स केस में करेंगे।
Petitioner is not present at call. Don't make false statement before this court. You are an advocate. You are appearing in your own case. You should not be wearing the band.
सर फॉल्स केस अब देखिए,
Yes.
इन्वेस्टिगेशन करिए सर, हमको डरा रहा है सर।
Please call.
Original side daily list item number 1 to 4.
What is this, sir?
My lord, I am
Mr. Surana is not to be seen for a long time.
I am suffering. I was suffering from ear problem and then eye problem. So that
Everything is all right
it's okay
now.
now.
Super.
My lord, the brief facts in this case are that Dr. Nirmal Palit was the SSC. Revenue filed an appeal before the AT&T, and in the midst of appeal, Dr. Palit expired. So department brought in his wife as legal heir under section 159, and they issued notice for hearing. Wife was suffering from acute malignancy, so she was taking her treatment in Chennai. So she did not receive the notice. After that, expired order was passed by the
Your
tribunal.
Lordship, kindly similar to your Lordship last order passed on 4th October 2024.
1, 2, 3, 4, Lordship, we have filed the application seeking addition of party in this matter as per Lordship's direction in the.
My lord, the direction was that the executor be taken as a party, additional party. We have filed the petition, and we have served the petition on the executor.
All right. Subject to objections that you may raise,
Lordship.
we will allow the application.
Lordship.
And my lord,
subject to the impleadment
at this one.
No.
My lord, the only prayer is that let the matter be sent to the tribunal because it will hang on.
That we have to amend the cause title, then the matter will come up. Heard the learned advocates for the parties. In terms of the leave granted by order dated 4th October 2024, application has been filed for addition of parties, namely the executor of the alleged will of Dr. Nirmal Palit. The prayer sought for is not opposed by the learned advocates appearing for the respondent, hence application allowed.
My lord,
cost title shall
next week it may be taken.
not next week. Let the cost title be amended accordingly. Who will amend it? Department.
1, 2, 3 for your lordships.
For admission of tax matters, item number 8.
Yes.
Lord, I'm led by Mr. Padiwala. I understand that my learned friend Mr. Day mentioned the matter based on his availability by taking his name. Today he is in some difficulty, I'm told, but I'm ready to go on with the matter, my lord.
Yeah, subject to your convenience.
Right.
Or you want Mr. Padiwala to come? We can give you a date on Tuesday.
The coming Tuesday?
You check your diary. Mr. Roy Chaudhary and Prutu Doria, they are ever ready.
They are available.
They were ready.
Because of his reason, this matter is adjourning for a long time.
No, Mr. They said short point. But the other Philips India matter, what he mentioned was the DIN number.
Right.
So then Supreme Court has granted a stay of the Delhi.
The Tata Center matter was stayed by the Supreme Court.
So there is a stay.
Yes. He allowed an
your lordship's order in Tata Medical, where your lordships have been pleased to hold that if a DIN is not mentioned in the order, then that order is invalid. Now against that there is a stay of no doubt, because initially, my lords, there was a decision of the Delhi High Court in the case of Brandix.
The order was only simple point, Mallet. It is not an illegality, it's an irregularity. Supreme Court said.
They've not said in so many words, but anyway, that no doubt.
Our reasoning was it is substantive.
Right, man.
Issue is substantive in terms of the CB board circular.
Absolutely.
It is not a procedural irregularity to be rectified.
Absolutely.
That was for our view. Delhi High Court also. What is it? Benetica? Some Benetica?
Brandix. And my lords, in those cases, in Tata Medical, for example, my lord, the order was passed, and on the same day, there was another letter which was issued, which said that the DIN of this order shall be so and so. Still, my lords felt that that is not sufficient to save the order. Now, in my case, the gross facts are that the order is ostensibly dated 31st March 22, and the letter is on 23rd January 23. Almost after.
Issue is on the point of jurisdiction.
No.
They have an alternative remedy.
No, what shall you know?
177 crores.
In the light of the stay granted by the Honorable Supreme Court, should we not, as judicial discipline, we have to await the...
Right, my lord. So therefore, what I'm saying, my lords, is that really I had raised 3 issues before the Honorable Single Judge. One issue was DIN, undoubtedly. The second issue was with respect to limitation, that this order is barred by limitation because it is passed. It should be regarded as passed on the date on which it is communicated to us, which is in January 23. And even if one takes into account the extension as per TOLA as well as the COVID extension which were given by the Supreme Court from time to time, the maximum date, even as per the revenue, is up to September 22. So therefore, on that ground, the limitation, it should go on the base of limitation. The third point which we had raised, my lords, is with respect to 144C, because he has to first pass a draft order and he has to allow me an opportunity to go to the DRP raise objection. Whereas in this case, he has straight away gone ahead and passed a final assessment order. He's issued a notice of demand. He's issued a penalty proceeding. I mean, he's initiated penalty proceedings and series of decisions which say that this would tantamount to the order being regarded as a final assessment order. And therefore, this is in gross violation of the procedure which is there. Now, the learned single judge has recorded all my submissions on 144C, but not adjudicated this issue at all. So he only says 2 things. One is, insofar as DIN is concerned, he says it is stayed by the Honorable Supreme Court. Insofar as the limitation is concerned, he says it's a mixed question of fact and law. Now, really, there is no dispute about the fact that till the date January 23, the order has not been served on me at all. And once it is not served, Supreme Court, I cited all the decisions before him, that once it is not served...
But did they file their affidavit in
They filed their reply.
Yes.
They filed their reply.
And
Proceedings are complete.
How do they justify the limitation issue?
Lord, in fact, they filed a letter from the department to where they categorically accepted that this was.
Judgment of the limitation point. Then, my lord, we said the dean is not an illegal. It is an
No,
illegal.
keep the din other. The other
Then
two
the
issues.
Red chilies entertainment, that is also not bound by us. Well, we only said you have an alternative remedy. You can say everything before the appellate authority.
Correct.
Go there.
That is true.
Only to deny 20% payment, you come to the writ court and delay.
No, if you see, the Supreme Court has carved out exceptions. If an order is barred by time, if an order is in violation of principles of natural justice,
This is their allegations.
lack of jurisdiction. So
I don't think, madam, there is lack of
if
jurisdiction.
this comes to court, then the writ court has to examine whether any of
Court examine everything. Malad, if Malad will go through the writ court's order, it is absolutely perfect. Malad, if this is the
But
today's
if-
situation, Malad,
because-
kindly give
no,
us
no.
the direction
Be-
to file our affidavit.
because of the order of stay of the Honorable Supreme Court, what we will do is we will stay the assessment and the demand. And we will take the matter out of the list, give you liberty, because on the first issue, if he succeeds, the other two become academic.
Then fix the date, Malad.
We'll fix a date after 2 months, then we will do it. Because another split verdict has come yesterday, a day before.
Yes, ma'am. That is on the other issue of ROCA, on that whether the 153 timelines will apply to the draft order or to the final order. And there, Justice Nagratna felt that it will apply to the final order, whereas the other judge, Justice Sharma, felt that it will apply to the draft order. And therefore, on that ground, so Lord Justice Nagratna's order is completely based on the provisions of the act, say that we don't go into what is the consequences, what will be the consequences, so many notices, so much revenue, we are not concerned with that. We'll look at the law. The law says this, and therefore we are saying that it will have to be quashed. That because the law is very clear that it will only apply to the final assessment order. And therefore all the limits of the passing of the draft order, you're going to the DRP, and then you coming back from the DRP, thereafter he has to file an order. Everything has to be completed by the date which is suggested in 153. That is her order, very categorical. Insofar as the Lord Justice Sharma's order is concerned, he has gone more on the thing that if you do this, what will be the consequence? And on that footing, he has ultimately said that no, you have to take into
So now
account.
it will go to a larger bench.
Now it has to go to the larger bench. So
Now, Anjan, you give the other two matters, Phillips.
no, those are serial number 18 and 19.
18 and 18. No, 19 and 20.
Oh, I'm sorry, 19 and 20. 19 and 20.
That one we will say.
Trying to do.
The Tata that judgment you are carrying,
Right, my lord.
and the stay order of the Supreme Court.
Yes, my lord. So, Lord,
Malad is going to stay the order.
Yes.
We are not doing anything, Malad. The order from the very beginning, we are not doing anything.
We can't trust you. We can't trust you.
Lord, I'll file copy.
If suppose we adjourn this manner sine die, immediately you will issue a demand.
No, we have done
A
nothing.
bank attachment,
The order was passed.
then 271 1C penalty you will do. All they will do. Where is the order of the learned single bench?
Single bench. Yes, my lord. Lord, my lord will have the
Page 306.
yes.
We have got APOT 80 of 2025.
80.
80.
Yes. So, my lord, 80 is with respect to assessment year 18, 19. And the first year was 17, 18, which is 81.
All right. Please give 81. But it's a common order in
It's
both.
a common order for both the years. My lord will just have 81. So the order dated 12th March 25.
Starts from 303 in item 80.
81, which is the page number?
Yes, ma'am.
81 is also right.
Page 97.
No more.
Page 297.
297.
Page, sir?
Yes, my lord. It is
Page number 297.
297.
297.
297.
297 is.
That will be in volume 3.
Volume 3, yes.
Where is the finding in respect of the first issue, A?
Yes.
298, yes, the issues have been jotted down, A,
Right.
B, C, D.
And thereafter, my lords, if I may refer to, my lords, page 309.
309, yes.
No, which is internal page 13.
30, yes.
I have taken into account the submissions advanced on behalf of the petitioner as well as that of the respondent authorities, and on a consideration of the various issues canvassed, I am of the view that the same need to be dealt with. The learned advocate on behalf of the petitioner stressed that the judgment relied upon in Whirlpool referred to by the respondent relates to the issue of jurisdiction. According to the learned advocate, since limitation is a question of jurisdiction, the petition is entitled to invoke the powers vested in the High Court under Article 226. I have considered such submissions on the issue relating to limitation. Now, this is his finding on limitation, and I'm of the view that the question of limitation involves mixed question of fact and law. As such, summarily considering the same only on affidavits may not be appropriate in the background of the facts and circumstances. Such proposition has been laid down in so and so. So this is his finding on limitation. Then, my lords, the next issue which has been canvassed by the petitioner relates to DIN being absent in the assessment order, which is rendered the order bad in law. To that effect, a series of judgments have been placed by the learned advocate appearing for the petitioner. However, the issue is too technical, and the judgment delivered in case of Tata Medical has been interfered by the Honorable Supreme Court. There has been stay of the order wherein the proceedings were quashed by the High Court because of absence of DIN. Needless to add that Tata Medical, the order was passed by the Appellate Authority, and Honorable High Court exercised its power under Section 260A and not under Article 226. So that is insofar as the findings on these two issues is concerned. Thereafter, everything is only on alternate remedy. I'll just read that. Another issue which is requires consideration by this court, as has been canvassed by the private respondent, is that when an alternative and efficacious remedy is available, whether the High Court should exercise its jurisdiction under Article 226 of Constitution. Needless to say that very recently, Bank of Baroda versus Farooq Ali Khan, it has been observed that the statutory tribunals are constituted to adjudicate and determine certain questions of law and fact. The High Court should not substitute itself as a decision making. Further, in PHR Invent, the Honorable Supreme Court has been pleased to hold as follows. The law with respect to entertaining a petition under Article 226 in case of availability of alternate remedy is well settled. Unfortunately, the High Court overlooked the settled position that the High Court will ordinarily not entertain a petition under Article 226 if an effective remedy is available. That this rule applies with greater rigor in matters relating to recovery of tax. So all this was really with respect to recovery. And then, while expressing the above view, we are conscious of so and so. All this is a reproduction from that decision. And then in the aforesaid judgment, the Honorable Apex Court relied on the previous judgment in the case of Chabildas, where it was as deprecated that where efficacious alternate remedy is available in the statutory form for redressal of grievances, writ petition should not be entertained, ignoring the statutory dispensation. Then, my lord, they refer to paragraph 15. And this para 15, in fact, is in my favor, because here, my lord, what they say, thus, while it can be seen that the court has recognized some exceptions to the rule of alternate remedy, that is, where the statutory authority has not acted in accordance with the provisions of the enactment in question. That is my exact case, that you have not followed the provisions of section 144C. My lords, page 18, paragraph 15. So they themselves set out this exception, but they don't follow it. My lords, then, or in defiance of the fundamental principles of judicial procedure, or has resorted to invoking provisions which have been repealed, and or where the order has not been has been passed in total violation of principles of natural justice, then therefore in those cases, so if these exceptions don't apply, then the bar of alternate remedy applies. And then after considering various other decisions, I mean,
2023, there is another decision, though not under the Income Tax Act, the Radhakrishnan Agarwal or something.
That is
right,
we have shown.
right, my lords.
And where Justice Chandrachud has culled out all
Right,
the
my lord.
earlier decisions.
That also is referred to, and that specifically refers to, my lords, will just have
But one thing, Mr. Roy Chaudhary, it was pending for more than a year. It was entertained. In other words, admitted.
Well, the only point we argued
Affidavits
there,
were called for.
only point we argued
They
there.
say more than 12 hearings took place. And to throw it out on the ground of alternate remedy, there are a lot of decisions
The
which
issue is
say
very simple.
is inequitable.
If they prefer an appeal before the alternative remedy jurisdiction, they have to pay 20% of 177 crores.
Maybe. But
To
then,
avoid that, they have come to the
no,
decision wasting time.
they have raised 4 issues. You decide the 4 issues on merits, including the 5th issue raised by you, saying that writ petition is not the appropriate remedy. But the 4 issues need. Where are your grounds of appeal?
Right.
Grounds of appeal, page number.
Lords, at start at page 4 in this appeal. Well, I've referred to each and every point.
No, this is stay application. Memo of appeal.
81. Milords, 81, page 4. Milords, I've raised grounds. Memorandum.
Yes, yes. Page 4 of memo. We have taken the completely take armor for.
Please take note. These appeals have been filed by the assessee, challenging the order passed by the learned single bench in 2 writ petitions, namely WPO 500 of 2023 and WPO 499 of 2023. 499 and 500 of 2023. The assessee in both the appeals is the same company, and the challenge in WPO 499 of 2023 is to the legality and / or validity of an assessment order dated August 12, 2022, passed by the first respondent under section 143 within bracket 3, read with section 144 capital B of the Income Tax Act 1961 within bracket the Act for the assessment year 2018-19. In WPO 500 of 2023, the challenge is to the legality and / or validity of the assessment order dated 31st March 2022, passed by the first respondent under section 143 within bracket 3, read with section 144 capital B of the Act relating to the assessment year 2017-18. Both the writ petitions have been dismissed by separate orders, but the reasoning given by the learned single bench is identical. As against the said orders, the present appeals have been filed. Before the learned single bench, broadly 4 issues were raised. Which have been culled out by the learned single bench in the following manner.
Prior to that, kindly see page 307 once.
Yes, main assessment is a stakeholder because the shop documented what is decided for an interior should have put it in. Hello, key order today. Stakeholder then. Much better. Supreme Court will come in the
Hadron Saturday.
Tata Medical Center.
Good. May I audible, my lord?
But Supreme Court you have, it was there separately. Lord, that Supreme Court I will tender it. But I'm accepting that it has stayed the operation.
No, he has to give it reference. Reference
number. Right, man. I'll just. Because I'll give that.
Reference number is he asking for the number. SNP. SNP number.
Well, item number 9, my lord, I am appearing on behalf of the petitioner, my lord. Well, may I audible, my lord?
Can you get print out? No. That is not the issue. Lord, that was really more on non-application of mind because he's referred to wrong sections in his. But otherwise, I have not raised that issue.
With the provisions of the enactment in question or in defiance of the principles, the fundamental principles of judicial procedure, or has resorted to invoke the provisions which are repealed, or when an order has been passed in total violation of the principles of natural justice, etc. Therefore, there is no total bar for a constitutional court to exercise jurisdiction under Article 226 of the Constitution of India, despite existence of an alternate remedy under the relevant statute. That apart, we note that the writ petition was pending for more than a year and affidavits were exchanged. And at that juncture, it would be, more than 12 hearings have taken place. And to throw out the writ petition on the ground of alternate remedy will be inequitable. This is a prima facie finding and will not affect the respondent revenue from canvassing all issues when the appeal is heard. In the light of the order passed by the Honorable Supreme Court granting stay of the order passed by this court in the case of Tata Medical Trust, and also in the case of, and also an order of stay.
My lord, Brandix.
Order of stay of the judgment delivered by the High Court of Delhi in CIT versus Brandix Mauritius Holding Limited, 2023, 149 taxman.com, 238 within bracket Delhi, we are of the view that the appeal should be entertained and kept pending and await the decision of the Honorable Supreme Court. In the meantime, if the demand issued against the petitioner, appellant writ petitioner is enforced, then the appeal itself will become infructuous. For the above reasons, there will be an order of stay of the order passed by the learned single bench, as well as the assessment order, the assessment orders which were impugned in the writ petition, and the consequential demands that have been issued to the appellant writ petitioner. Let the appeals be listed listed in the monthly list of November 2025. Liberty to mention liberty is granted to the learned advocates on either side to mention in the event the Honorable Supreme Court disposes of the appeal earlier.
Lord, may I just say two things? One is I've got that citation for the Supreme Court saying that I will give my to the learned. And my lords have said 4 issues.
We have struck off C.
Right. And there is one issue which is separately discussed by the Honorable Single Judge, which is at internal page 5. That issue also may be mentioned, that because my challenge was also on that ground. Bottom of page 5. A further issue which was canvassed before this court in respect of assessment order being invalid and bad in law.
You can add, whether A, B, C, and D, whether the assessment orders impugned in the writ petition are invalid and bad in law, as it was passed without complying the mandatory procedure provided under section 144 capital C of the Act. Okay. Yes.
Extremely great.
And what is this item matter, sir?
No, that is my learned friend's appeal challenging order of the tribunal, where they have said that because reopening was beyond a period of 4 years and there was no failure to disclose.
Which is the other matter you mentioned? Item.
So, my lords, item 19 and 20 is what my lords have disposed of.
Item 8.
Item 8.
Yes.
Item 8.
It is your appeal.
Yes.
This is only one point we have said, that the learned tribunal, there is a cross appeal, both in the ITAT. Well, we said the non-considered of explanation 1 of 147, that was, kindly see page 61 of my grounds. That's the only point we have checked. Page 61.
1 second.
Then kindly come to page 55 of the tribunal's order.
Now show us the reasons for reopening.
Page 10, my lords.
Page 10, yes.
That is in page 10, internal page 2. The reasons recorded of reopening as follows.
Sir, you culled out this from their PL account.
P&L balance sheet computation.
Where is the question of, please come, this appeal by the revenue filed under section 260 capital A of the Income Tax Act 1961, within bracket the Act, is directed against the order dated March 31, 2023, passed with Income Tax Appellate Tribunal B Bench Kolkata, within bracket Tribunal, in ITA number 1285/KOL/2019 and ITA number 1939/KOL/2019, both relating to the assessment year 2010-11. The revenue has raised the following substantial question of law for consideration. Page 4, paragraph 7, only one question. We have heard so and so, so and so. The short issue which falls for consideration is whether the Senate Tribunal was right in allowing the assessee's appeal and dismissing the cross appeal filed by the revenue against the order passed by the Commission of Income Tax, within bracket appeals 4, numerical 4, Kolkata, within bracket CITA, dated 29/3/2019 for the assessment year under consideration, AY 2010-11. The reopening of the assessment and the order of reassessment under section 147 of the Act was put to challenge. The learned tribunal has carefully examined the factual position, more particularly the reasons that have been recorded by the assessing officer for reopening the assessment. The reasons have been culled out in the assessment order dated 27/12/2017, passed under section 147, read with section 144, read with section 254 and 143 within bracket 3 of the Act. On a bare reading of the said reasons, it is found that the assessing officer has not brought out as to how the assessee had not disclosed full particulars, and there was an intention to evade payment of tax. In fact, the reasons itself has been culled out from the books of accounts of the assessee, the bank statements, the P&L account, the excise duty register, and all other records. And as rightly held by the learned tribunal, the assessing officer has not mentioned anything about the failure on the part of the assessee to fully and truly disclose all relevant information. As has been held in several decisions, reasons are the manifestation of mind of the assessing officer. Full stop. The reasons recorded should be self-explanatory and should not keep the assessee guessing for the reason. Full stop. Reasons provide link between the conclusion and evidence, semicolon. The reasons recorded must be based on evidence. Furthermore, the assessing officer must disclose in the reasons as to which fact or material was not disclosed by the assessee fully and truly necessary for the assessment of that assessment year, so as to establish vital link between the reasons and evidence. These being conspicuously absent in the reasons recorded by the assessing officer, the learned tribunal was fully justified in allowing the assessee's appeal. Thus, we find there is no question of law, much less substantial question of law, arising for consideration in this appeal. Accordingly, appeal fails, dismissed.
Lord, this is the decision of the Honorable Supreme Court stating that
this is Supreme Court stay order.
And
Tata Medical.
Another topic.
Lord, I want.
And what? You were present in court when the stay was granted?
Yes, in Supreme Court? No, my lords, I was not.
No, what was passing in the mind of saying
that? Lords, what I've heard, I was not there personally. What I've heard is that they said that if you do this, again the same thing, that so many assessments will go. That so not on the law point, but it is only that so many assessments will go. That is what worked in Roka in this draft order versus that is what worked in the other one, Tola, which now ultimately has been decided by Rajiv Bansal, and that is what I'm told also worked in DIN.
Rajiv Bansal also, that was what was passing in the mind of the Supreme, because everything will go.
Everything will go.
So therefore, they validated the.
Ultimately, it was just another lifeline which was given, and they said that in case
the judgment of Justice M.R. Shah.
No, that yes, that was Ashish Agarwal, which was Justice M.R. Shah's, and thereafter Justice Chandrachud, who decided Rajiv Bansal.
Yes. Now we'll come back to the list.
Lord, at all possible to have a date in September for assessment year 17-18? Just my lords have said 19 in that those matters which are there. Is it at all possible to have it in September sometime?
Because of this, we have granted stay of the assessment order.
Right.
Both the appeals we have.
Because my lords, ultimately, according to us, the short issue is whether 140.
Because we are closed, rather the court will be closed. I will not be here in October for puja. We don't have long summer vacation. So safer side we include in November. In case in September it gets over, you mentioned.
Very well.
If that issue, we have said two alternatives. If that issue is decided in their favor, everything goes. If it is otherwise, the other 2-3 issues we will consider.
Yes. Obliged, man. Deeply obliged.
Poll tax matters, item number 5.
May it please your lordship. This assessment, my lord, was done on the basis of my lord search and seizure that has been conducted, and my lord this assessee before your lordship is my lord the other person, and his assessment was done under 158 BD. This is a block assessment, and my lord initially, when my lord I should my lord point out a gist of this matter. Initially, my lord, when 158 BD notices my lord was served upon the assessee, my lord assessee have challenged that on the ground that the assessing officer, while my lord issuing that notice, did not my lord record the reason for which my lord it proposed to my lord proceed against the assessee. That challenge, my lord, was canvassed by filing a writ petition, and my lord, the honorable single judge, my lord, have my lord cancelled dismiss the writ petition. My lord, that order was assailed, my lord, before the division bench, and my lord, the division bench, my lord, have uphold, my lord, the findings from the learned single judge. Then, my lord, the assessee, my lord, have assailed that order, my lord, before, my lord, the Supreme Court, and Supreme Court find that there is no illegality, my lord, with regard to, my lord, proceeding with the notices. So, my lord, that point is no more, my lord, come to assess the assessee. So, my lord, ultimately, my lord, the assessment has been done in respect of the person primarily on whom 158 BC was proceeded. And my lord, that assessee, I shall indicate from my lord the record, has my lord challenged that assessment order before my lord the CIT appeal. And CIT appeal, my lord, has confirmed the addition. Now, the present assessee before your lordship is a person against whom 158 BD proceeding has been initiated. Now, if your lordship kindly take the trouble to see once again 158 BD of the Act. My lord, I put the old one because I'm reading from 2019 Finance Act. 158 BD, my lord, I'm placing before lordship. The only Yes. Yes, that is of 2024. Then, no, the question of satisfaction of the assessing officer is always there. That is there.
No, if my lords are looking at the 2024, the provision is substituted. So my lord may kindly look at the footnotes. The old provision would be there because the 158.
This is before substitution, my lord.
My lord. Return. But kindly see, it's opened at that page. It's in the part of the footnote 158 BD at the top. My lord. Well, as long as my lords are looking at the provisions which were there before 2024, it is all right. My lord, I will just. Well, this is all right because this pre-2024. Yes, sir.
I am placing that before. Where the assessing officer is satisfied that any undisclosed income belongs to any person other than the person with respect to whom search was made under section 132, or whose books of account or other documents or any assets were requisitioned under section 132A, then the books of account, other documents or assets seized or requisitioned shall be handed over to the assessing officer having jurisdiction over such other person, and the assessing officer shall proceed under section 158BC against such other person, and the provisions of this chapter shall apply accordingly. So, here, the assessee before lordship is such other person. Originally, 158BC proceeding, has been initiated in respect of that person, and not the assessment order has achieved finality. Now, the such other person is the assessee before lordship. I shall be indicating the materials that has been found during the course of search and seizure against the assessee before lordship. That is appearing at, first of all, page 115 to 116 of your lordship's paper book. It has just given a brief notes of the fact which I have just indicated to your lordship. Search. This is page 115 of your lordship's brief.
Paper book.
I'm sorry. 150.
19 আছে 19 119
এই ম্যারেজ
119
In fact, the stay petition is much better because there may be lot of typing mistakes.
My lords.
Yes. Even now,
and if you make the stay petition with index and chronologically you file it.
If the documents are
First one should be the notice which was issued 142, 143, 1. Then the details called for show cause notice. Then the reply given by the SSC, the assessment order. Then the memo of appeal before CIT, CIT's order, memo of appeal before the tribunal, tribunal's order, grounds. That is so in my court.
yes, yes. I found those missing here.
And
it has not been
without
maintained.
your assistance, the court cannot find the page numbers. That's the biggest problem.
And even this is not telling between us. The paper booklet which I'm using.
So therefore,
has
119 my page.
the people who type this out, they are not people who with the law background, etc. Instead, you scan that and make a document.
So
sometimes you miss out 2 lines,
yes.
and they are also not able to identify.
That is the
Ultimately,
reason
our judgment will be found fault.
of a different footing.
I think this paper book system requires some change.
It's
Because
better
in
to have the photostat copies rather than not the
And now all orders are uploaded.
Yes.
Assessment orders are e-assessment orders. Appellate orders are also uploaded. So you download clear copies, make photocopy of that. You prepare 2 for the court, 4 for you with an index, and the index should contain a jurat signed by the advocate. Here we find nothing.
Yes, because this is not even a verified document. Paper
Yes.
is just the type copy of the materials.
This oath commissioner is there. He knows nothing at all.
Nothing.
And
That's the
after
problem.
6 p.m. only everything happens.
Because nowadays, even your lordship on several occasions, my lord, have actually dispensed with filing of the paper book for these reasons. Because these are
And the paper, stay petition doesn't contain the index.
yes.
And if it is an intra-court appeal, there are repetition.
Yes.
You file the entire writ petition, plus you give the document. So you will refer to page 98. The other side will refer to page 165. Same document.
That's true.
Because you would have prepared it making notes. He would have prepared it making notes there. Something needs to be done. It's a waste of time and money. This hardbound, etc.
And the paper.
Space. So
and
much
and the
heat.
paper as well. Paper as well.
And the quality of the paper should be like this. This should be the line space. This should be the side margin.
It's not required. Now it is not required, my lord, because we can always, my lord, have it
Because
in a.
judges will develop allergy. Something will happen to judges.
This is the difficulties, my lord.
All right, you
If
note your point.
I may not, my lord, be able to, my lord, on the point out the actual page because not matching
No,
the assessment
order.
Assessment order.
Yes. The stay petition is here, Anja.
Statement.
You give that.
You call me
The other one.
না মানে জজ সাহেবের সঙ্গে মিলবে না স্যারের সঙ্গে মিলবে না আচ্ছা তুমি তাহলে বলে স্যার
See, this would have been more easier and handy too.
assessment
All right, you proceed.
Before my learned friend proceeds further, I may just only point out the assessee is in cross-objection with the leave of the court on the question of jurisdiction. So my learned friend said it's a closed chapter, it is before my lords. I just wanted to point out it's the
cross-objection is there.
it is a part of the paper book. The cross-objection is included in the paper book.
Page number?
Page 5 of
on the first document, page 5. এটা পেপার তো মিলছে না আমার সাথে difficult.
Well, at page 5 is where it starts. The paper.
Page 5, yes.
But I think there is a. My lords are having.
Page 1 is the memorandum of cross-objection.
Yes.
Lordship.
Page 1 it starts.
Yes.
Appellant has preferred the appeal being so and so.
No.
From the order of
There
the
are the index
income
came.
tax tribunal, block assessment, whereas the appeal was admitted by so and so on so and so. When the representative was not represented, whereas upon the matter being taken up on June, so and so and so and so, granted liberty to the respondent to file cross objection and begs to prefer the cross objection under Rule 22.
আমাকে একটু বলে দিও স্যারকে একটু বলে দিও। একই জায়গা থেকে তৈরি হয় এরকম কেন হয়?
আলাদা তৈরি করেছে, স্পেশাল তৈরি করেছে। দেখো রিপোর্টটা মধ্যে
এই অ্যাসেসমেন্ট অফ রিফ্যাক্টটা দেখাবো কিন্তু ঠিক আছে পেজটাই মেনশন কন্টেন্টটা মেনশন
এখান থেকে সাজেস্ট করবে।
So cross objection has to be heard first. If 158 BD initiation of proceedings or notice itself was bad, everything should.
because my lord, even my lord, the Supreme Court, while my lord,
They say that Supreme Court order granted leave.
yes, towards that issue,
the jurisdictional.
towards that issue. Now, my lord, the point
So
that
they
was,
have to argue first.
but the point, my lord, that was possibly, my lord, is
Yes, did the assessing officer of the searched party, did he record satisfaction?
yes, my lord.
Or did he record saying that this is unaccounted money, not of the assessee before him, but of a third party?
No, there was a recording of satisfactions by that assessing officer. That is the reason, my lord, for which, my lord, if I could, my lord, indicate to your lordship,
But
while
their
my lord,
contention is otherwise.
Supreme Court, even, my lord, taking note of that fact that that assessing officer may not, my lord, pass.
That liberty was rightly granted because they had no occasion to canvass that point. That was the searched party's assessment, which was challenged, etc. went up. But when they are aggrieved, they are entitled to canvass this.
No, my lord, the search party, my lord, have actually challenged the order up to CIT appeal. Thereafter, my lord, that order, my lord, has actually achieved finality. Now, my lord, on the basis of that materials, my lord, the SSC has been proceeded with. Now, my lord, the initially.
So, therefore, whether this satisfaction has been recorded.
Yes, now, my lord, the Supreme Court had got the occasion, my lord, while, my lord, treating the SLP to, my lord, to my lord, justify that satisfaction is a part of the assessment order of that SSC. The search party assessing, my lord.
Initiation of proceedings.
কোন কত পাতা বলো
129 of 5 পাতা
So the assessing officer of the search party has to record satisfaction.
Yes, my lord.
He has done so.
And that has been done. That's the reason for which, my lord, this has been primarily held against the assessor.
Then we'll see that assessment order. Where is that assessment?
If I may just indicate, the assessing the assessing before my lords, his assessing officer, my lord, records in the assessment order that he has received a communication dated 5th August 2003 from the Delhi officer. Delhi officer is of the search person. Based on that, my lord, this notice is issued to me, my lord. He records his satisfaction on 28 November 2003. I received the notice shortly thereafter. So, my lord, that's how the matter proceeds. Now, my lord, before the tribunal for the first time, the learned Commissioner CIT DR, he produces a satisfaction note dated 29th August 2002, to which there is attached a list of the people against whom the proceeding should be taken.
That is the letter of the assessing officer at Delhi.
Yes, even the 5th August 2003 letter is of the assessing officer Delhi, which is not referred to in the assessment order. This 29th August 2002 is the date of completion of the assessment of the search person. Yes. And this document, this office note, never surfaced at any stage. For the first time ever, before at the hearing before the tribunal, the CITDR produced it. Now, that office note with that list, that was dealt with by the tribunal itself in that SMC share brokers case, a decision relied upon by the tribunal on merits in deciding my matter. So it was pointed out from the decision itself, because we were otherwise not prepared on that because he produced it. But the decision itself records that this particular document is antedated. So once that document goes, then what we are left with is 5th August 2003. Now, this is almost a year, a few days short of the assessment in the case of that French portfolio. The Delhi assessment, the search.
When that assessment was completed?
29th August 2002.
Then this letter was issued on 5th of August
2003.
And the purported other document which surfaced?
That is 29th August 2002.
On the date when it was completed?
Yes. Now,
and that has been found to be an antedated
document by the tribunal in the very order which has been relied upon by this bench of the tribunal in deciding the matter on merits in my favor. But on that part, they did not look at that part of the decision of the tribunal where this.
So therefore, if that document has been held to be antedated,
Lordship,
and that decision of tribunal affirmed by the High Court,
yes,
then they cannot refer to 29/8/2002 letter.
Lordship.
So they are left with only 5th of August. 5th of August, one point they raise is almost a year, close to a year. Second, does it record satisfaction?
Well, that is on the merit part. Number, as far as the time period is concerned, the matter traveled to the Honorable Supreme Court in Calcutta Knitwear's case. The Honorable Supreme Court is pleased to hold that there are 3 points of time when the satisfaction can be recorded. But one is simultaneously with initiating proceedings in the case of the search person. The second is during the continuance of the proceedings in the case of the search person. The third is immediately after the assessment of the search person. Because he has to decide when he's making the assessment whether it belongs to the assessee being assessed or someone else. Because if it belongs to that assessee, then he has to assess it. Now, in our case, the tribunal has reproduced that particular portion of the assessing officer's order, the Delhi officer, where he says, I'm adding it here on protective basis because till I find out to whom it belongs, I will then take steps. So protective here, and then he adds that amount. So 29th August, that is the assessment which is made. So I've lost track. At 5th August, so I was on the point that this is almost a year after. So the question is, if 29th August 2002 goes out of contention, whether the 5th August 2003, having been issued almost a year after the assessment in that person's case, whether that is legally valid or not. So the Supreme Court said immediately after, there was a group of some matters before the Honorable Delhi High Court, where the notice was issued 10 months or thereafter, from 29th August. Same, sir. So the Honorable Delhi High Court was pleased told that it is too late. It's not immediately after. That decision was followed by the Honorable Gujarat High Court in another matter. There's a 9 months delay. So there again, following Delhi, they said, no, this is not. So that is the point note on the limitation part, because if
No, he made the very same addition as a protective basis in respect of the search party.
yes, no, there was a much larger addition. Our addition is some 12 crores. There's some 130 odd crores.
And they had not challenged it beyond the CIT appeal stage.
But I am not fully updated on what has happened in their case, because when I am a share broker, but I purchased and sold shares on their instruction. I remitted the profits by check. They encashed it. Their case was that no, this money has been given back in cash. When the search papers do not show that anything was given, do not implicate me in any manner. It is that man's statement.
All right. Can we see those two? First, we have to see the assessment order of the search party. That is 29/8/2002. Then the alleged letter of the Delhi assessing officer. And the letter dated 5th August 2003. It is there in the...
No, the assessment order, that portion is extracted here. Now, I must point out that 5th August is also referred to by the assessing officer in the assessment order here. But the 29th August 2002, but that document is not with me presently.
But it was produced before the tribunal.
Yes, by the revenue for the first time ever.
Copy not given to the
assessor. I'm not able to recall. I have in fact made an inquiry whether that document is there or not, but it was produced by the...
Then revenue should have it. But then there is no point in relying on that letter. That the tribunal has already said it is antedated. So if on the ground of delay, how do you explain? What does the tribunal say on the ground of delay?
No, the tribunal proceeded on the basis of the 29th August 2002.
Yes. Tribunal did not say on that score.
But tribunal did not notice that decision.
No, that decision is noted in the later part of the order when adjudicating the matter on merits in my favor. But not on this part, the tribunal records my submission that it is antedated, but does not refer to that part of the decision where that discussion is there. I have copies of that decision, but I can show from that the tribunal has recorded that it is antedated. Because my officer, he makes no reference to 29th August 2002 when he is making my assessment. He issues the notice to me in November. But the notice is dated 2nd December actually. It is dated 28th November, received by me on 2nd December 2003.
2nd December 2003.
Yes, I receive it. It is dated 28th November. That is the date on which he records the satisfaction. 2nd December.
But what is crucial is the satisfaction of the assessing officer of the search party.
That is 5th August 2003 is what our assessing officer says.
On the ground, and the limitation point the tribunal did not consider.
Because 29th August 2002 is the date they went with, therefore they said it is within time.
But are you aware of those decisions which says 9 months is too long, 8 months is too long? Here it is close to a year, 15 days short of a year. And you have to produce that 5th August letter is enclosed.
No, it is. If my lords are pleased to have the assessment order.
It has been made a part of the assessment order.
So that page
must have been part of your cross objection.
No, no document is annexed to that note. Page
119. No?
Starts with 119 assessment order.
But can you see page 120 of my lord's page?
120 and 120.
It is a bold heading seize materials which are forming a basis of satisfaction of undisclosed income. Then he says information was received from
No, it's better we see that letter, Lordship, 5th August. And you produce that 29th August.
Yes. Assessment order.
That record you produced it before the tribunal for the first time.
Yes.
And also the decision of the Delhi Tribunal, which has said that document is antedated.
Because in the subsequent cases which traveled up to the Honorable Supreme Court, they did not rely upon 29th August. Because that itself shows that because you kindly see this one. But I draw attention to the relevant pages. Not kindly see at page 9. Paragraph 14 to 17. Rising out of the same.
Up to para 70, 14 to 17.
14 to 17. Now, kindly see this subsequent.
This order was affirmed by the Delhi.
Yes, it does not. I'll hand up that copy. Kindly see, this is that This is arising out of the same search action. If my lords are pleased to see me at page 696, the second page, paragraph 2, in the table below
29th August 29.
Yes, ma'am. Kindly see the table, my lord. Date of search 3rd August, Manoj Agarwal Group. Date of assessment 29th August 2002. Date of satisfaction note for other person, July.
15th July.
Yes, 15 July. Then 26th August, there is one. Then June also there is June, 4th June. And then 2004.
January 2004.
Lords. And paragraph 4, if my lords are pleased to have the paragraph, after the table, the court is referring to the Supreme Court judgment in Calcutta knitwear's case.
Assessment কিন্তু 29th August এর চিন্তা 5th August এর পর থেকে হবে যায় না ট্রাইব্যুনাল দেখা ট্রাইব্যুনাল ডকুমেন্ট থাকে না বলছো তুমি
When it was admitted,
नहीं ऑर्डर नहीं उठना पड़ेगा नहीं भाई 2011 में it was
this was not the issue.
admitted on this only surely
Only this was.
So that was a case of 10 months.
Yes, 10 months more, 10 months or more, my lord.
And 1.5 years. But we like to see that satisfaction note.
Lordship.
That will be better.
29th August 2000. 29th August 2000.
29th August, they have to produce.
We'll try, my lord, but I don't know.
Or I think that may not be required because that has been invalidated as an antedated document. 5th August 2003. Because in this judgment, from paragraph 5, they deal with whether that is the satisfaction note at all. So we have to touch upon the merits. But if we have to say that there was no satisfaction.
But I should be able to get on Monday. I don't have it.
If you go, one of you can help us with one photocopy.
Yes, certainly.
Of this, we'll give this set to you.
But I think that I have the original application, but I'll make copies from that.
Easier.
But perhaps my copy may be marked, so I may.
We'll ask Court Officer to give so that you can make 4 copies. Easier to.
That will be better.
And
the rule has to be amended.
Was the Delhi High Court not dismissing the appeal against SMC protest?
This was on the ground of cross-examination.
But no, if the revenue was not contesting that
No, but
objection of the
in this matter, my lord, this ground has been taken regarding, my lord, the principle of, my lord, natural justice, but cross that has been found to be, my lord, not tenable because, my lord, the assessee during the course of, my lord, the proceeding before the tribunal had, my lord, withdrawn that ground because, my lord, assessee had, my lord, given, my lord, the opportunity to cross-examine the, my lord, the persons concerned.
So if you have not agitated this ground before the Delhi High Court, you can't do it here.
No, my lord, here, my lord,
you can't raise the point based on 29E.
That's the thing.
That has become final.
That's the thing.
Validated the 29.
This is of the search button.
We have heard this also. Let a copy of the satisfaction note dated 5/8/2003 be placed on record. List on Tuesday.
Next one.
Give this stay petition to them. Cross objection and cross objections. And one short note you can make with the events, whatever.
I'm grateful, man.
Item number 6.
This is that short matter. My lords had taken it online the other day, but my lords felt that it should be looked at in court. The question is, my lord, whether the amount was written off in the accounts. So, I was placing before my lords the profit and loss account. If my lords are pleased to have page 18.
Yes. That is reserve or bad debts.
Yes, page 18 is the profit and loss account. And on the left-hand side, my lords will find
bad debts written off.
Bad debts written off. This 8,97,000. This is the precise amount in contention. It was written off in the profit and loss account as bad debts written off. Then kindly take page 25.
Yes.
This was page 25. Kindly see the last entry at the top. Reserve for bad debts as on 31st March 2005. Then kindly see party name, opening balance, bad debt written off during the year. That is the heading. Closing balance. Now kindly see the last entry. Unique agencies, that is the party with which we are concerned with. Bad debts written off during the year 8,97,676.72. And then it is then gets added to the closing balance. Now this amount then kindly in the balance sheet kindly take note page 17. 1 crore 38. On the right-hand side, sundry debtors stated to be good 1 crore 81, less reserve for bad debts 1 crore 38. So 53 lakhs 19,000 is the balance. So the question is whether this accounting, when it is written off in the profit and loss account as a bad debt written off, it is taken to the reserve where again it is shown as a bad debt written off. Then ultimately it is reduced from the debtors in the balance sheet.
That 13,803 has been reduced.
Yes, so our concern is only with that 8,97,676. So whether or not this amounts to a write-off, because it is profit and loss account shows it is written off. Then it is routed to the balance sheet through the reserve for bad debts. In the reserve for bad debt also, the heading is bad debts written off.
Bad debts written off.
And then it is reduced. So whether this amounts to a write-off, because ultimately, if you look at it in the profit and loss account, it is written off. Then it also goes to reduce the debtors in the balance sheet. Now, on the last occasion, my learned friend had mentioned about the checks. There's some checks in hand, but the assessing officer had made inquiry from this particular debtor. In course of the assessment, they denied that any amount was payable to me. But I, in fact, was holding some checks which they asked me not to deposit. So, because of that, I wrote off that entire balance of 8,97,000 because they were disowning. They said we will not pay. So that is what my learned friend was referring to. Kindly see at page 22. This is the party ledger for that financial year. Kindly see that just above the closing balance, checks in hand up to so much, up to 31st March 2004, rupees so much, plus during the year so much, not deposited as per party's advice, reversed. So that, because when they're unwilling to pay, they said, please don't deposit the check there, and to the officer they write that we're not going to pay. There's nothing.
So therefore you had to write it off.
I had to write it off. So this is that part number.
In the reserve at page 25, the heading says bad debts written off during the year.
Yes, ma'am.
So he should have compared this total closing balance
with
what was reflected in the balance sheet as of 31st March.
No, the revenues case seems to be that this does not amount to a write-off. The officer says, the authorities have also said, tribunal has said that this does not amount to a write-off. Although in the profit and loss account, it is clearly mentioned.
Because the title of page 24 says, reserve for bad debts.
Yes. Because of that, it is routed through that account, but ultimately, what
tribunal also did not accept.
Tribunal is on the basis that it is not written off. The tribunal has relied upon Micromax case. Micromax, not the Honorable Madras High Court. My learned friend had handed up a copy on the last occasion, but that was a case where a provision was made. In the accounts, it was described as a provision. It was not. They follow this judgment in deciding the matter against me. If my lords are pleased to note the facts in Micromax note, paragraph.
Para 3.
Yes, Lord.
The assessee, but the assessee had not actually written off the bad debts of these as irrecoverable in his books. Influenced by so on so on.
But the last line of paragraph 5. And with paragraph 7, the tribunal's finding is reproduced. But kindly see the second last line of the quotation. At the time of hearing, learned counsel for the assessee filed 6th annual report, wherein at page 9, the provision for bad debts has been clearly stated under the head expenditure. So in the profit and loss account, it was stated as a provision for bad debts. Then in paragraph 9, learned counsel for the department submitted that a mere provision of bad debt is not sufficient to get the benefit of the above provision, and it is only when the debt is actually written off as irrecoverable in the books of account that a claim for bad debt can be allowed as deduction. On the other hand, the submission of learned counsel for the SSC is that it was only an inadvertent mistake committed by the SSC that a narration was made in the profit and loss account as provision for bad debt. So, not in the profit and loss account, then not kindly take note. Paragraph 17, where the law is summarized by the court. Thus, it is now a mandatory condition that deductions can be allowed as a bad debt only when it is actually written off as irrecoverable in the accounts and not on the basis of a mere provision. And then note paragraph 30. In the present case, it can be seen that the SSC did not write off the debt in question as irrecoverable in his accounts for the previous year. Hence, on the plain language of section 36(1)(7), the debt cannot be allowed as a bad debt. It may be that the SSC committed an inadvertent mistake, but we cannot go by the notions of equity in tax matters. Making a provision is not the same thing as writing off a debt as irrecoverable.
But here the assessing officer, how does he say it is merely a provision?
Yes, kindly
it's
take
a reserve.
Page 32.
But he did not compare the balance sheet.
No, that is why I was referring to that Vijaya Bank's case, where the court was pleased to hold that ultimately, if it is reduced from the debtors, then it amounts to a write-off.
That letter where they said you can't deposit the checks. No.
No, the Vijaya Bank's case, as a matter of law, the Honorable Supreme Court considered this kind of a presentation where in the balance sheet the debtors are netted off by reducing the amount. So the court was pleased to hold that this amounts to a write-off. But kindly see that paragraph 2, if my lords have the reported decision, Vijaya Bank, paragraph 2 at page 168.
But on facts, the assessee's case is a better case.
Yes. And there's one other fact note which the Honorable Supreme Court noted under section 41(4). If subsequently there's a recovery, it gets taxed. It's not that the assessee just by claiming a bad debt. That's noted at the last page.
Before part 10, para 10. Lastly, in the any event.
Yes, that
41(4). So the excess amount, if any, will be taxed as
Yes.
profit and gain.
In fact, note in this very profit and loss account at page 18, if my lords are pleased to see, note, on the income side, but fourth item from the bottom, bad debt return of recovered, 2,20,000. So note, they are also offering but page 18, note the profit and loss account on the income side, right-hand side, note the from the bottom, note the fourth item, bad debts return of recovered.
Recovered.
So note whatever they are recovering, note they're also including it. It's not that note they by claiming a debt as bad, note they're then they're not offering to tax if there's a recovery later. So this, of course, is some other recovery, but so they are quite
Very short.
But I think they didn't place it properly before the AO.
Yes, you will kindly see page 34. Page 34.
Yes.
Now, last 1, 2, 3, 4, last 6 lines. The account of the unique agencies was verified. The proprietor Sri Vijay Krishna Majhi has stated in his statement on oath dated such and such that the total purchase during the year from the assessee was such and such. There was no outstanding for payment, nor he has given any check of such and such for this year. Keeping in the view of above fact, the claim of bad debt return of such and such is disallowed. If party says there is no due, there is no question of provision of bad debt, there is no bad debt also.
But where from you got this statement?
Statement, this is the statement of the parties who has given the check.
But
This is the
they have
assessment of
mentioned in their balance sheet. I'm sorry. In the profit and loss account, not profit and loss. Party ledger. Then you should have put the statement to them.
it will not given. My note, the note in the papers is that no cross-examination was given.
Not the cross.
And clearly they have mentioned that 3,88,000 check.
Sometimes it happens when the check was issued. Sometimes it happens we say don't
Present it.
present it now. You present it for after 7
That's what they have said. Not deposited as per party's advice.
Thereafter, whether that have been deposited or not, these factual aspect, this factual aspect did not looked by anybody.
Please come. This appeal filed by the assessee under section 260 capital A of the Income Tax Act 1961. Within bracket, the act is directed against that part of the order passed by the Income Tax Appellate Tribunal B bench Calcutta within bracket in ITA number 531/KOL/2010 dated 18th November 2014 for the assessment for the assessment year 2005-06 so far as the second issue in the said order regarding disallowance of bad debts is bad debts. The assessee has raised the following substantial questions of law for consideration. Page number 12 and 13, 5 questions. We have elaborately heard so on. The assessee filed the return of income for the assessment year under consideration, along with the tax audit report under section 44 capital A capital B of the Act, appending the computation of income. The said return, the assessee had shown the total income of rupees 33,28,170. The return was processed and thereafter notices under section 143 within bracket 2 and 142 within bracket 1 was issued to the assessee. and the case was discussed by the assessing officer with the authorized representative of the assessor. Assessment was completed under section 143(3) on 31/12/2007, determining the total income at rupees 76,46,460 after making disallowance of bad debts amounting to 8,97,676 and rupees 34,20,618 in aggregate under different heads of income. As could be seen from the material papers, the assessee had produced all documents and details with regard to the names and addresses of the debtors, the amounts referred to in the bills, and the reason for treating such sums as bad debts as appeared in profit and loss account for the year ended 31st March 2005. Furthermore, the assessee demonstrated before the assessing officer from the profit and loss account, balance sheet, ledger account for the period 1/4/2004 and 31/3/2005, statement of reserve for bad debts, over the assessment was completed, the said addition. Agreed by the same, the assessee preferred appeal before the Commissioner of Income Tax Appeals. Commissioner of Income Tax. Now, where is the CIT appeals order?
That page 77, that page 83, 84.
The appeal. Before the Commissioner of Income Tax Appeals 33, Calcutta, within bracket CIT. The appeal was dismissed by order dated 31/12/2009, against which the assessee filed appeal before the tribunal, which has been dismissed. The short issue which falls for consideration in the incident case is whether the assessing officer was justified in disallowing the bad debts on the ground that it was only a provision. In this regard, we were required to examine the factual position, and we have done so. As could be seen from the balance sheet as at 31st March 2005, in the current assets, loans and advances column, it has been stated as follows. And in the reserve for bad debts, as on 31/3/2005, there are three columns. There are four columns, namely the name of the party, the opening balance, the bad debts written off during the year, and closing balance. In the said entry, as against unique agencies, the bad debts written off during the year has been shown as 8,978,7676.72, and the total closing balance is 13,803015.64. When we compare this figure with that of the balance sheet as at 31st March 2005, as noted above, the figures match, and it is evidently clear that the reserve for bad debts, as shown in the said tabulated statement, has been deducted. It is no doubt true that the heading of the format is inverted comma reserve for bad debts as on 31/3/2005, but what has actually been shown in the table is the bad debts written off during the year. Thus, it appears that the assessing officer did not compare this factual situation as shown in the bad debts as shown in the column bad debts written off during the year with that of the balance sheet as at 31st March 2005. Furthermore, the assessee's case stands strengthened on perusal of the party ledger with regard to unique agency. It clearly shows that the checks which were handed over up to 31/3/2004 for rupees 66,100 during the year and rupees 38,800 were not deposited as per party's advice and reversed. This will clearly show that there has been a written off, the bad debts have been written off and not as a provision. However, the assessing officer, while completing the assessment, appears to have relied upon a statement of one Vijay Krishna Maji, who stated to be the proprietor of unique agency, who has given a statement stating that there was no outstanding payment payable to him, nor anything was issued. This statement was never put to the assessee, and the assessee had no opportunity to cross-examine the said person. Therefore, the said statement should be held to be inadmissible and could not have been used by the assessing officer to complete the assessment. Apart from that, while affirming the order passed by the assessing officer and the CIT appeals, reference has been made by the learned tribunal to the decision in the case of Commission of Income Tax versus Micromax Systems Private Limited, 2005, 148 Taxman 486 within bracket Madras. We have carefully gone through the said decision and we find that the decision is clearly distinguishable on facts. In the said case, the assessing officer found that the assessee had not actually written off the bad debts as irrecoverable in its books of account. This was noted by the tribunal and accepted the case of the department. Before the High Court, the department contended that mere provision of a bad debt is not sufficient to get the benefit of the provision, and it is only when the debt is actually written off as irrecoverable in the books of accounts that a claim for debt can be allowed as deduction. The assessee argued before the High Court that it was only by an inadvertent mistake committed by the assessee that a narration was made in the profit and loss account as provision for bad debts. The court took note of the amendment to section 36 within bracket 1 within bracket Roman 7 small 7 and held that it is a mandatory condition that deductions can be allowed as bad debts only when it is actually written off as irrecoverable in the accounts and not on the basis of a mere provision. And after taking note of several decisions, it was held that the plain language of section 36 within bracket 1 within bracket small 7 Roman 7 of the Act, the debt cannot be allowed as bad debt. And even though the assessee is stated to have committed an inadvertent mistake, that same cannot be gone into as there is no equity in tax matters, and therefore held that making a provision is not the same as written off as bad debt irrecoverable. In the preceding paragraph, we have noted the factual position, and we find that the assessee has actually written off the bad debts during the year, and this has been vividly reflected in the balance sheet as at 31st March 2005, which appears to have not been, which has not been properly appreciated by the fact-finding authorities. While on this issue, it will be beneficial to refer to the decision of the Honorable Supreme Court in Vijaya Bank versus Commission of Income Tax and another 2010 323 ITR 166. Two questions arose for consideration in the said case. Namely, the manner in which actual write-off takes place under the accounting principles. Full stop. The second question is whether it is imperative for the assessee to close the individual account of each debtor in its books, or a mere reduction in the loans and advances column, inverted comma, or debtors to the extent of provision for bad and doubtful debts is sufficient. The Honorable Supreme Court took note of an earlier decision in the case of Southern Technologies Limited versus Joint CIT 2010 320 ITR 577 within bracket SC. In the said decision within bracket Southern Technologies Limited bracket close, it was held that to understand the dichotomy brought in by way of the explanation to section 36 within bracket 1 within bracket 7 of the Act, one must understand within inverted comma how to write off inverted comma close full stop. If an assessee debits an amount of doubtful debt to the profit and loss account and credits the asset account like sundry debtors account apostrophe s, comma, it would constitute a write-off of an actual debt. However, if an assessee debits provision for doubtful debt, inverted comma, to the profit and loss account and makes a corresponding credit to the current liabilities and provisions, inverted comma, current to provisions, on the liability side of the balance sheet, then it would constitute provision for doubtful debts. At this juncture, it would be relevant to quote the at this juncture, it would be of utmost importance to quote the relevant paragraph of the decision in Southern Technology. Sir, from paragraph 6 till 9, you quote the entire full stop. The above decision would come to the aid and assistance of the assessee, both on facts as well as on law. Apart from laying down the legal principle, above legal principle, the Honorable Supreme Court has pointed out that section 41 within bracket 4 of the Act lays down that where a deduction has been allowed in respect of bad debt or a part thereof under section 36 within bracket 1 within bracket 7, then, comma, if the amount subsequently recovered on any of such debt is greater than the difference between the debt and the amount so allowed, comma, the excess shall be deemed to be profits and gains of business and, comma, accordingly, comma, chargeable to income tax as income of the previous year in which it was recovered. And therefore, the assessing officer is sufficiently empowered to tax such subsequent repayments under section 41 within bracket 4 of the Act. On facts, we find from the profit and loss account for the year ended 31st March 2005, the assessee has shown the bad debts which were written off and subsequently recovered. And that was in excess, sir.
Yes, no, this was the written off.
And the tax was paid.
This, yes.
Which was in excess than the amount which was greater than the debt payable, and on the said component, tax has been paid by the assessee. Thus, for all the above reasons, we hold that the tribunal committed an error in affirming the orders passed by the assessing officer as well as the CIT. For the above reasons, the appeal is allowed. The order passed by the tribunal as well as the assessment order and the order passed by the CIT are set aside. And consequential direction should be given.
No, the deduction of this amount, Lord, if my lords are pleased to have the order of admission. Duto copy. The deduction of that particular amount has to be allowed.
And the deduction claimed by the SSC for the sum of rupees 8,97,676 should be allowed on the ground it is bad and doubtful debts.
Bad debt written off.
Bad debt written off. You said SSC has released the following submission. It is admitted. The appeal was admitted by order dated 9th October 2015 on the following substantial question. Only one question.
I'm great.
Sir. Paragraph 3.
I must say one inspiring instance in this case also. Case of 2015, tax effect is very less, small amount. Whatever professional charge fees charged by Mr. Khaitan at that time, the check was given by the client, it was returned.
May I permit to pay one leave, my lord? This is my lord.
He is doing his case free of cost.
Not appeal, not ITT appeal, my lord. There are two assessment here involved, my lord. Not the tribunal passed, my lord, one order, combined order. My lord, may I permit to file, my lord, two appeal with the leave of the one Xerox copy, my lord?
No.
Because my lord, one
One
original
will
copy
file
is
certified copy, other
yes, Xerox copy.
Xerox.
Deep
Deep
Right.
We understand your lordship is unwell and yet has sat for a matter. We are
No, this
extremely grateful.
matter is very important.
Appellate side, daily list, serial number 1, 2, 3.
Then what
Lordship,
has to be done?
My learned friend has something quite unfortunate to report to your lordship regarding.
This is a very informal report, my lord. Yes. I have shown it to my learned senior friend for the state and also. This is a copy. একটাই আছে আমার। দিয়ে দেবো আপনাকে। ওই রিপোর্ট আমার পেয়েছি।
এটা চলে গেছে খিদিরপুরের পেশেন্ট, তার কার্ড চলে গেছে বীরভূমে।
My goodness. They sent it to Birbhum.
But after this.
But then the medical board in NRS has sent a WhatsApp to send the details back.
Yes.
That is yet to happen.
Yet to come. I have been told to contact them by the end of this week.
Please follow it up.
But I have had this unfortunate incident. Just I had a talk with
Actually, see, the problem is this PWD certificates are mostly handwritten.
Yes.
And people who go and approach the person, they are not very well educated.
Yes.
And the person with disability is already suffering.
Yes.
So then they say, no problem, we'll do it. But all along when it was in NRS here, address it at Kidirpur, why you send it to Birbhum?
Just I had a talk with the director of health. He that this problem can be solved by the director of medical education, her authority. He is the
whoever is the authority.
But if my learned friend can approach him, but just I've given a suggestion.
Lordship, what we are worried about is not
That
one
probably
stray
can't be
case.
solved.
This accountability of Lordship, in this perspective, I was mentioning, Lordship, when we surrender, Lordship has seen that on the last occasion you had passed an order saying that when there is an increase in the percentage of disability, then we have to surrender the cards. And we are worried that once the card is surrendered, unless a time frame is given, we will not get the new card. So we would
simultaneous.
It should be simultaneous.
but it will never, because there is one point in the flow chart when your lordship sees, they are saying that they're going to have a medical board again to evaluate the amount of disability. So holding of a medical board cannot be a very rapid exercise.
It can be done within 10 days.
Lordship, it fixes a time limit. Otherwise, we surrender our cards and in the meantime, we do not get the next card.
Because in my case, after this incident, I could not approach some other people also. They were not agreeable.
No, don't do it. Don't do it.
Yes.
Let that be sorted out.
Yes.
Oh, now, what
Lordship,
further directions?
Yes, Lordship sees the directions one by one.
Now, first we will deal with this. Reference may be made to the order dated 22/7/2025, in which the directions issued earlier were referred to, and certain further directions were also issued, which we will deal with in this order chronologically. In which paragraph of the order we referred to this UDID?
Lordship, in this particular order, 22nd July.
The first issue which we wish to take up is with regard to the difficulty which was highlighted in obtaining UDID, all capitals, card.
24.
It was submitted that different hospitals follow different operating procedure and there was no standard norms. and that one of the government hospital insists upon the residential certificate to be issued by the councillor of the local municipality. Taking note of the said submission, it was directed that all hospitals in the state of West Bengal should adopt a uniform procedure with regard to production of the details for obtaining UDID cards, and definitely a certificate from the councillor of a municipality or a pradhan of a panchayat should not be insisted upon, but other records can always be accepted, such as Aadhaar card, ration card, bank passbook, voter ID, driving license of the parents of the patient suffering from rare disease. In this regard, the appropriate authority of the state government was directed to pass appropriate orders, and the order was directed to be placed before this court. Where did we record about the SOP? That was in the previous order, I think.
No, it's in this order only.
That is
But from 22 onwards, your lordship has said.
That is Government of India. That is dated 13/6/2024. Correct?
Yes.
That is the SOP.
Yes. Yes, it's not in this order.
On an earlier occasion,
1st July.
the court took into consideration the
1st July order.
standard operating procedure within bracket SOP framed by the Government of India, Ministry of Social Justice and Empowerment, within bracket Department of Empowerment of Persons with Disabilities, bracket close, dated 13/6/2024. This SOP was to handle the cases where the type or percentage of disability or both of PWD, P capital W small capital D, has changed, semicolon, or where PWD has already been issued UDID card / disability certificate migrates permanently to other state / UT. The learned senior advocate appearing on behalf of the petitioner in WPAP 9 of 2023 has placed a note highlighting the difficulty faced by one of the person suffering from disability, where the said person had followed the SOP and accessed the UDID portal for entering all the required details. Thereafter, the previous UDID card was surrendered and the receipt of such surrender was downloaded and printed. It appears that the said person had visited NRS Hospital, NRS Medical College and Hospital on 7th of August 2025 at about 2:30 p.m. and approached the office of the medical board of the said hospital, but they did not have any information regarding surrender of the UDID card, and they are also mentioned that they were not aware of SOP or notification. After producing the copy of the notification and the orders passed by this court, it is stated that the officials evinced interest and came to the assistance of the said person. However, the entire data of the said person was transferred from NRS Hospital to Birbhum Zilla Hospital on account of an error recorded in the disability certificate as Birbhum, when the address and other details of the person reflects the place of residence at Kidirpur, Kolkata. It appears that the officers of the medical board of NRS have sent a WhatsApp message to Birbhum Zilla Hospital requesting to forward back the data of the said person, namely Somyadeep Chakraborty, to the NRS Hospital, and the said person is awaiting further action. The copy of the note has been handed over to Sri Mukherjee, learned senior advocate appearing for the state. And the appropriate authority of the state government shall look into the matter and take effective steps in remedying the mistake. Furthermore, all the concerned officials of the medical board of the various hospitals be sensitized about the SOP, the terms and conditions mentioned in the SOP and other related notification, so that such errors do not occur in respect of other PWD candidates.
The Lordship would kindly fix a time period if we surrender our cards.
That apart, the state government has to also fix strict timelines within which the process will be completed after the surrender of the UDID card in cases where the person's disability is increased. We are aware of the fact that the assessment has to be done by a medical board before a fresh certificate is issued. However, the persons should not be made to wait endlessly, and a timeline should be fixed within which the medical board has to be constituted for the person to be examined. And in our opinion, a time limit of 10 days would be reasonable, so that further compliances can be done and the fresh card can be issued not less than 20 to 15 days from the date on which the medical board examines the fitness of the concerned person. Then, yes, sir. Then what else we said?
Lordship, we'll go by the order one by one. Paragraph. One very relevant question Mr. Mukherjee had asked me was, how many patients are there if the question of giving them a monthly fee of 5,000?
We wanted total number of patients so that government can.
As per the portal, I have a copy of it. I found that there are 573 persons registered under the portal, of which the DMD patient, I'm told, is 310. So it's not a very large figure, which they can immediately, if they want, they could start. Whosoever goes to the portal, goes to the authorities saying that his name is registered in the portal and can produce a card showing that they are a disability patient, then that person could be given that particular amount of 5,000 rupees per month.
What you can do is, you make the proposal initially for 500.
Yes, that would be.
And let the finance approve it, let the amount be kept. Then you verify the credentials.
Yes, of course.
Registration, etc. and start disbursing. Because we can't fix, this is a varying figure. Children are born every day.
Yes.
So you can't fix in the state of West Bengal. There will be only 527 persons with rare disease for the next 100 years.
No. Possibly cannot be.
So this is a variable figure.
Variable.
So what you can do is, for the time being, considering the number of people, you take an abstract figure. Let us say 500. 500 people, 5,000 rupees per month.
That should.
With that, you make a
the
proposal,
finance should.
financial approval, minister approval, honorable chief minister approval. Then that funds can be parked under a particular head, and it can be issued. In our order dated 1st July 2025, a suggestion was made to the state government to consider providing a stipend of rupees 5,000 per person suffering from rare disease. And the appropriate authority of the state government was granted liberty to respond to the suggestion put forth by the court by filing a report in the form of an affidavit. Mr. Mukherjee, learned senior advocate appearing for the state, submitted on the last occasion, that is on 22/7/2025, that the matter is under active consideration of the state government. Today, in the course of submission, it is stated that the appropriate authority of the state government would like to know as to how many people, the number of persons to whom stipend of rupees 5,000 a stipend has to be disbursed. We are informed by the learned advocate appearing for the petitioners that as of now, there are nearly 400 persons who are registered in the portal.
Actually, 573.
573 persons are registered in the portal. However, no, all 573 will not get.
All are rare disease, but amongst that muscular dystrophy is 300.
Portal
Muscular dystrophy.
who are suffering from rare disease. And out of the 573, 310 are suffering from muscular dystrophy, for whom the stipend has to be increased as per the suggestion of this court. Since the number of persons who are likely to be affected in future cannot be ascertained, for the present, the state government can arrive at an approximate figure, which in our opinion can be 500 persons, and appropriate steps be taken by the various authorities of the state government so that the funds are made available under a particular head of account and disbursed to the persons who are entitled to such stipend upon causing verification of the requisite details. In this regard, let a report in the form of an affidavit be filed by an appropriate authority of the state government on the next year. Then what else, madam?
Lordship, on that, another suggestion that is there is that rare disease clinics are held only on one day, that's a Wednesday. They were earnestly requesting at least 2 days in a week if they are called for the clinic. Otherwise, they say it's for a very limited period of time also on Wednesday. Many patients do not get the opportunity of them.
Please take down. One more issue which has been pointed out is that as of now, the special clinic for persons with rare disease is being conducted once a week, which according to the petitioners is inadequate. We also feel so. Full stop. The appropriate authority of the state government shall consider to increase the clinic to at least 2 days in a week. And in this regard, a report can be filed by the appropriate authority on the next hearing date as regards its feasibility and other connected aspects. And what about the wheelchairs, madam?
Your Lordship, 2 advocates have already contributed for 5, Mr. Bisharup Bhattacharya and Mr. Shiv Shankar Banerjee. Lordship, Mr. Paritosh Sinha also agreed to make the payment. He has said for 10 wheelchairs. My clients say that once that entire money comes, they will start purchasing the.
Why?
They will do. They should start.
You start purchasing. Don't wait for the entire money. See, at least this will give confidence, or
yes, that something is
happening.
Something is being done for them. And
but if GST is
yes, that
is excluded, that would cost.
It is within your hands.
No, this is for the central government.
The directions no, it has to go to the board, sir. It will not happen. You pay GST and take it. That's fine. See, after all, they are contributing. Let them pay tax. Probably you give them the bill, they will have input tax credit. Pratyush Sinha will have credit. On the earlier day, earlier, a suggestion was put forth for providing wheelchairs for the use of the persons suffering from rare disease. And the learned advocates were benevolent enough to come forward with the contribution.
For 5, each of them have paid for the 5 chairs.
And
the
as
5
of now, the contribution to cover the cost of 10 wheelchairs has been received by the Writ Petitioner Society. The Writ Petitioner Society shall purchase the 10 wheelchairs and distribute them
on 7th September, which is the Rare Disease Day.
on 7th September, preferably on 7th September 2025, which is marked as the Rare Disease Day, World Rare Disease Day.
Lordship.
As and when future contributions are received, the society shall continue to purchase the wheelchair and distribute the same to the persons suffering from rare disease. Further, the Writ Petitioner Society is directed to address a letter to the persons who have contributed, appreciating their gesture.
Yes, they should. Lordship, in this perspective, I see at paragraph 11 of your Lordship's last order, 22nd July, your Lordship had made a very good suggestion that it is open to the other members of the bar to also come forward to make their contributions if they so desire. Lordship, in this perspective, I was praying that could we put up something in front of the lift or somewhere?
Let the bar association will put up a notice.
If that is
No sticking near the lift, no photo. If there is a notice board with the permission of the Registrar General, you can put it in the notice. No sticking. Very difficult, madam. You go to City Civil Court.
it looks very dirty. It
dirty.
looks no. If we put up a board, which is not a permanent.
All right. The Petitioner Society is at liberty to bring to the notice of the 3 wings of the bar about the suggestion made by this court in its order dated 22/7/2025, suggesting that it is open to the other members of the bar to also come forward to make contributions if they so desire for the purpose of purchasing wheelchair for the persons suffering from rare disease. This can be brought to the notice of the 3 wings of the bar and other stakeholders.
May I make one application? That whether a request can be made to the secretaries of the head to calculate it within the members, because there are WhatsApp groups.
That is all. You take care of letters.
Announcement is there.
This order you enclose, definitely they'll do it.
Order will be announced.
And you can do it in Government Pleader's office. You can do it in ASG's office.
Yes.
Your Lordship, I am told by my clients with regard to paragraph 14 that we were supposed to get 2 beds. I mean, your Lordship had asked it be increased to 5 beds. Now, what has happened is I'm told that the head of the Department of Neonatology, who was present on the last occasion, Lordship, she has made requests, but often her requests are turned down.
Who turns it down?
They say that somebody from the health department should be there. That's only how it can be done.
No.
She has made.
No, last time that Dr. Madam was here, she said that detailed project report and site drawing has been submitted and vetted estimates will be submitted shortly. So let Mr. Mukherjee get instruction from Madam. We won't say anything on that now.
Lordship, what is happening? The practical difficulty.
You can't go by your oral statement, madam. See, after all, she is a very
she has been
officer.
Yes, and we are appreciating her gesture. She has been making a very.
If it goes,
It depends upon the government.
No. If it goes from her desk or her hospital to the government, and if there's a deadlock, we will deal with the secretary. At that stage, we will issue.
Or your Lordship can direct the Secretary Department of Health to look into the matters at an early date, so that the problem can be resolved.
No, this was for paragraph 14 is exclusive ICU unit.
Yes.
Where is 5 beds?
No, the 5 beds was in the 1st July order.
Somebody should make a note of all these things. 1st July order. 1st July. 5-bedded ICU
Lordship.
by our order dated 1st July 2025 in paragraph 7. A recommendation was made for a 5-bedded ICU unit to be provided at the ground floor at the Kolkata Hospital, Police Hospital, of which 3 beds can be reserved for persons suffering from muscular dystrophy and the remaining 2 ICU beds for persons suffering from other rare diseases. In this regard, when the matter was taken up on 22nd July 2024, the court was informed about the response given by the head of department of neonatology, nodal officer, COE of rare disease, IPGME and R, SSKM Hospital, Kolkata, dated 22/7/2025, which we found to be encouraging, as detailed project report with site drawings and estimated vetted estimates, site drawings and vetted estimates were to be vetted estimates and financial implications will be submitted shortly. It is submitted on behalf of the petitioners that there is not appreciable progress in this regard. The secretary, the principal secretary to government, Health and Family Welfare Department shall examine this aspect, and we would request the principal secretary to give his personal attention to this matter so that the 5-bed ICU unit is established in the Kolkata Police Hospital as suggested in the ground floor. That's all.
Lordship, the last thing I was coming, paragraph 20 and 21 of your Lordship's order dated 22nd July, where your Lordship had talked about the sleep study, and the government of West Bengal was supposed to inform the Honorable Court that they would give us the more or less price, and your Lordship had expected, had expressed that equipment should be, the state government should be proactive to accept those equipments in its inventory, take care of its maintenance. On this, my learned friend, Mr. Mukherjee, should give us a report whether he has talked to the government, whether, because if the Chamber of Commerce come forward, and I'm working with Mr. Sinha on that, if they come forward to contribute these machines.
No, if you get a general approval to accept the equipment. See, we were mentioning about last time, you remember? We were mentioning.
But
Yes. Yes, that's a very difficulty. Difficulty because until it is registered in the government's property, maintenance should be made by the PWD. Yes. Yes. Yes.
And the government is to maintain this.
I will take up the matter with the secretary. You are not a person.
Last week. বলছি Very good. Lordship, the last thing that I shall be, Lordship, this is not really related to the illness, but this is another request that has come from some of my clients. They're below poverty line. Now, they have said that the government will be providing food grains. It is strictly not in connection with the disease, but Lordship comes to the next page. Category AAY, 21 kgs of rice per family. They are praying for that. They are saying that if it's a
family.
Yes.
That's true.
His name will be in the ration card.
But if a
there is a card, Department of Food and Supplies card. Every family has a card.
Yes.
And a card.
If your name is included in the family card, you are entitled for supply.
And every family, if 5 members are there, there will be 5 cards.
5 cards.
5 cards.
Ration card.
You can't have a separate card for them. See, like the other lady, madam, one used to come. He has got 2 sons, herself and her husband. So there will be 4 cards for the family. You can't ask over and above that. What is this
Their suggestion is that there is something as Anno Yojana under which rare disease patients should be included.
That's why the government of India
AAY.
will only distribute it.
Antodaya Yojana. AAY card, separate card is there, issued by the state government, and they are saying that child has been included on that category.
So if you included in AAY,
that is my lord Antodaya Yojana card. AAY, that is, and that has been issued by the state government separately. Ration card is issued by the central government, and state government is issued this.
Ration card is issued by
the state government. State government, but on the aid of the central government, it is issued. Anyway, but the AAY card that has been issued by the state government particularly, that's the initiative of the state government, and under that category,
have double benefit.
No, subsidized food items is supplied by the central government to the state government. State government distribute to among the people on the basis of the card. If 5 members are there, 5 members will get the quantity of 20 kgs of rice per month and 10 kgs of.
No, in addition, can you issue AAY card?
Yes. No, that has to be ratified by the central government because subsidy is granted by the central government.
Subsidies are granted. AAY the subsidy central government দিচ্ছে না, state government পুরোটাই দিচ্ছে. In AAY, central government is not subsidized. Ration card is used, my lord, that is subsidized by the central government. But AAY, so far as my knowledge is concerned, subject to approval of my senior friend, that is issued by the state government. And my lord, the children have been included in the AAY category. And they are saying that this is the more subsidized.
Okay. So then, if you get yourself included in AAY, then you have to surrender the other card.
No, surrender the ration card.
No. This is separately issued by the melody. I'm saying that
you cannot have PDS items.
They are willing to surrender the ration card.
Something is saying.
Yes, surrendering. Yes, surrendering.
Willing to surrender that because this is coming out to be more beneficial.
More subsidy. They are saying that.
This is perhaps a completely
And
different category card.
Pardon?
This is perhaps a completely different category card. It has to meet its own parameters. Milord, I find from the Google Milord, it says Milord, it is issued to the poorest of the families. So if they are not fitting into this,
economic criteria.
There.
Based on disease, it cannot be.
No, based on disease, no. Only financial condition.
Madam, you get from Mr. Chatterjee, you pass on that notification to madam. Let her examine. We will not record anything today. Then you see the notification, how you can bring it within your.
Well, right now it is not with me, but notification is there.
You find out.
Notification is there.
Or
I know that.
If there is a residuary clause, it says any other category with the prior approval of the state government, then we can make a recommendation.
And well, that has been categorized by the state government itself.
Correct, sir.
But
AAY card has
has
notification
its
has
own
got
requirements.
various categories. Suppose, who is the poorest of poor? What will be the annual income? Whether it is annual income alone or a person should not own any movable property,
It's
either at
criteria is there, certainly.
and he should be a daily wage earner or an agricultural laborer and the sole breadwinner of the family. No other person is educated, no graduate in the family. There are a lot of categories.
And one card is a below poverty line, BPL, issued by the government. On the basis condition, the financial condition, if he has no agricultural land and he have certain income is there, that's the difficulty. And subsidized food is supplied by the Food Corporation of India and the subsidy provided by the central government and distributed by the state government through dealers.
It is central government.
It's central government.
It is central government.
Lordship, they are merely now praying that if they can show to the government that they are below poverty line, then they should not be.
You do some homework and come. You file an affidavit saying that how you will bring him.
Lordship kindly fixes a date before 15 September and Lordship, the last occasion we'll get.
Today we are on 13th of August. Probably 27th August.
Lordship.
List on 27th August, same and the same caption. But next time you the wheelchair, hand it over.
I shall.
Take photograph.
7 September. In fact, I was suggesting to them they have a program on 15th August, but that's too little a time.
If you can do tomorrow, whole 24 hours is available. If they have got stock of 3 or 4,
then at least in that occasion they can.
Yes, you can do it somewhere. You can take it to Red Road also. Madam can give it.
No, they have their separate programs. I've been invited by them. They will hold a program for these children on.
These 3 chairs you distribute. Take photograph.
I shall.
Write thanks letter to
Mr. Vishwarup Bhattacharya.
And
in fact, I also intend to give my portion within this period.
Very good.
Grateful. We are grateful to Lordship providing this type of chairs.
This one you like it?
Yes, it's a wooden chair which will last a lifetime.
Purely
yes,
teakwood.
In fact, ASG should be able to tell what happened to all the wooden chairs in the High Court. Chairs have got legs. That doesn't mean chairs can walk out on their own.
We find new chairs all station in Sharjah Lordship's court.
60 chairs we have placed.
And they're very hardy, beautiful.
When Justice Mishra was there, then that was wooden chairs of British period.
Yes.
That was replaced.
And
that's the
should not
have been done.
And those chairs which came in later were so bad. They were so soon.
In fact, the other day I think what is his name? Dr. Chakraborty. Samir Chakraborty. That who appears in Dr. Samir Chakraborty, senior advocate. He almost
fell.
It got tilted.
Those,
and that also you gave us blue color.
Well,
it is all Mukherjee's.
In my shortest career of 25 years, I have this amazing capability of sitting every time in a chair in High Court which is broken. First time I have broke the jinx. Thank you, Malad.
Maybe my learned friend is solely responsible for breaking all the chairs.
No, certainly
this won't break. In fact, this design
is last a lifetime.
This design is adopted in Jalpaiguri Circuit Bench building also. It has come out well, and it is through the WBDSL something. Some West Bengal something ACDCL or something through that, and one Mr. Sengupta, he only supplied this.
But they are very
totally. I requisition 70, so 60 are placed here, 10 in Registrar General's room.
In fact, gradually all the other chairs should be replaced.
So
but it's an expensive exercise.
To Madras High Court, Even if you sit for the entire day in that wooden chair, they are all right. In 1862, it was made. Still, it is preserved. That varnish is dark tan. You will not experience any back pain, any neck pain, nothing. Cushion chairs are very. See, if you're the instructing counsel, the matter goes on for 3 days. Let us assume a appeal bench like Birla Lodha matter. We were hearing.
Yes.
1.5 years, 1 year and 2 months. So all advocates seated here, seniors, Mr. S.K. Kapoor. So this will never make
This
you
will
tired.
never.
And initially they didn't put the bushes. Then our Bhaskar Prasad Banerjee said, "You do something, sir." They have fitted it last Friday. So let us see how long it goes.
Initially, all this type of chairs were supplied by Poborto Furniture in Bovaya. I do not know where.
So that's no more there. That shop is no more there.
Advertisement. Nothing should go out, sir. Once you make the inventory, this I already brought it into inventory of the principal seat. So nobody can take this out.
Lordship, the Almiras that are downstairs, those went for the judges' library. Some of them have been taken from there, but some still remain. Those also. Oh.
And in order to carry those, you have to hire special dispatchers.
Because it's wooden, it's of that 18th.
We just put dock. Special labor came.
Dock labor.
Because they are really good timber.
Very heavy. But where to keep it? You are willing to keep it in your residence, we'll send one. But periodic report you should send maintaining that shelf.
I would love to make that application, but I want one.
In fact, now the latest report of Public Works Department in consultation with IIT Kharagpur is building is sinking.
Sinking. So we'll have to abandon
Earlier
this.
report was that if sank, we arrested. The present is that corner is sinking. So they say de-escalate the weight, remove the weight, remove the weight. Actually, this is supposed to be the first floor. He says, no, the sinking effect will be because of the overload in the ground floor also.
Because of the old reason. Because
Chief Justice residence, the flooring has gone like this. The first floor veranda is like this. You put a chair with the wheels, it will automatically.
It's dangerous. Yes.
Over a period of time, nobody has thought about it.
In fact, the idea of putting in separate tiles was itself wrong. They put on added weight to this.
Yes,
whatever.
Actually,
That was the beginning of that.
That is the problem. Second, false ceiling.
Oh.
False ceiling for the building, which has got what is called the Madras Terrace. The Britishers called it Madras Terrace. It has got thin bricks, and it is lime. The plaster is not cement; it is lime mortar.
Lime mortar.
In fact, in Chief Justice's house, there was one lounge in the ground floor. I asked them to remove him because suspecting seepage. I have suspected heavy seepage. It was about to fall off. PW did a wonderful job. But what they do is that lime shells, they put it in water with some more chemicals. It will start boiling. And it will take about 4 to 5 days for it to become a mortar. Then you get those small bricks, which are available in West Bengal. Some of the bricklins are manufacturing that. And it has to be put in between. And all the girders are all imported from England. Still the marking is there. So you cover it up. See, that particular type of ceiling should breathe. This lime mortar plaster should breathe.
Yes, because at that time there was no concrete. That was the only way it was done. And
all old buildings are like that.
And they have been lasting for a very long time, longer than the present buildings that are being.
But then who is bothered? See, all you want is, you want wall-to-wall planning in Mr. Mukherjee's chamber. You cover this wall with plywood. What's happening inside, you don't know.
No.
So all put together, it has happened. Grateful.
We are very grateful to you, Lord.
Then we'll stop with this.
Yes, 20.
Don't mind.
20.
I got one rehearsal to go. This time your program is
Yes,
there?
yes.
Ah.
Incidentally, I will be rehearsing before your lordships. We have a slot booked at 4:30.
No, I'm not going to the auditorium. Here, in the
Oh,
guard
here.
of honor,
The flag hoisting practice.
Flag hoisting band. They said 4:30. They'll take me there.
The military brand presidencies are possibly now over the dispute.
Suddenly, that madam said somebody that her father is sick and she cannot report. Then
that was the major who was in charge of the GOC here. He was transferred, and madam has been replacing him. So yes, our father was in a serious condition. He has left. I will take up the issue with the request of Honorable Justice Champa Sarkar. They are saying that the entire branch has now gone to border areas for Operation Sindoor, but they are taking a step so that they can provide.
I told the registrar OS when he came to me, Soman Sarkar, forget the military band, state police band is enough. What to do?
Grateful.